grateful, my Lord. I've mentioned to my learned friend, I suspect I'll need longer than 3 o'clock to be finished properly this afternoon. What I've indicated to him, and I hope it's convenient to my Lord, that in terms of any additional time I take up today, I will surrender some time tomorrow by way of time for my reply and response. I want to make sure I get through the points that I need to communicate well. My Lord, I'd addressed, in general terms, the nature of the exercise at the third stage. What I'm going on now to address are my submissions about what I say should be the focus, not necessarily exclusive, but the focus on the terms of the contract. And in the context of IR35 legislation, the hypothetical contract. To be clear at the outset, I'm not suggesting that this is only a matter of interpretation of the terms. It is that, but it's also a question of consideration of their consequences. Let me be clear again what I mean by that. They're inevitable, they're inherent consequences as a matter of contract, not simply post-contractual conduct. An important preliminary point about the terms of that actual contract in this case, my Lords, is that the Upper Tribunal interpreted the first tier's judgment as subject to the Atholl claims point, as indicating that the agreement was intended to set out an exclusive memorial of the terms as between Atholl House and the BBC, in the sense that all the terms of the contract were reduced to writing. One sees that at paragraph 12 of the Upper Tribunal's judgment, which is page 75 of the core bundle. Your Lordships will see from paragraph 11 on page 75 the Upper Tribunal's reference to the debate about what the first tier meant in paragraph 80 of its decision, about the written agreements purporting to be a complete record of the action agreement. And one sees what the debate was. And then at paragraph 12, the Upper Tribunal said, in our judgment, HMRC's contention is closer to the mark. The contrast was between the agreement here and the incomplete and ambiguous contracts in Carmichael. And then over the page, in drawing that contrast, the first tier was concluding that at least on its face, the written agreement was intended to set out an exclusive memorial of the relationship as between the company and the BBC, and the Upper Tribunal emphasised that phrase. Now, accordingly, this was not a case in which the contracts were partly in writing and partly to be inferred from conduct. Rather, as we read the FTT's finding, all of the terms of the contract were reduced to writing. The only question being the extent to which terms that apparently formed part of the agreement were actually part of the agreement. And so, as it were, subject to the Atholl claims argument, this was a case in which the written agreement represented the action agreement. Now, obviously, in the context of Section 49 of our TPA, one is focusing on the hypothetical contract rather than the actual one, and there may be some differences in transposition between the actual to the hypothetical, but subject to that. The next point I make, my Lords, and I'm not going to repeat the detail unless my Lords would like to see it again in this light, but if one looks at the examples in ready mixed concrete, the 5 examples that Mr. Justice McKenna gives, bundle page 98, the focus in every case is on the content of the contract, not on any factors extraneous to it. So all of the examples have as a common thread the focus on what the contract tells you. In my submission, when one looks at subsequent and more modern authorities, although by using that phrase I don't mean to denigrate in any way ready mixed concrete, just more recent, have all taken the same approach as a matter of authority in focusing on the terms. So let me quickly, but necessarily, take my lords through 6 references. First of all, in Authorities Bundle 1, tab 14, which is Montgomery, the reference is at 293. And the way Mr. Justice Buckley summarised it at paragraph 19, in the second line, was that 3, really makes concrete, requires that all the terms of the agreement are to be considered before the question as to the existence of a contract of service can be answered. He then goes on to deal with the question of control.
Well, you're placing emphasis on terms of the agreement.
Yes, I am, my lord. What I want to show, my lords, is the pattern of authorities that refer to the test in the same way. In auto-cleanse in the Court of Appeal, I showed my lords this earlier. It's in the supplementary bundle of authorities at tab 3, paragraph 68, which is page 31. I showed my lords this earlier, but it's with a focus on this point, the way Lady Justice Smith puts it, at 68. The third requirement is that there should be no other contractual term, which was inconsistent with the relationship of the employer-employee contract of employment. Then picking it up with quasi, back to Authorities Bundle 2. Tab 24. So one finds the case at page 477.
477?
Please, my lord, that's the head note. And the reference is on page 483, paragraph 45. So having dealt with the argument that the tribunal judge at first instance had fallen into error of mixing up the question of mutuality in the sense of is there a contract with mutuality in the sense of is there a relevant kind of contract, his lordship went on to say at 45 the critical question was as to whether the nature was as to the nature of those contractual obligations. Were they such as to render it a contract of employment? To use the language of Mr. Justice McKenna, were the provisions of the contract consistent with it being a contract of service? And in that context, the most important finding from the evidence was that the employer, so-called, was under no obligation to pay the dancer or anything at all. Moving on in this same bundle at tab 26.
So that was actually a decision on stage 1.
It is, my lord. It's an example of a stage 1 conclusion, like the Varnish case, which I showed my lord, that's the British cycling case. The EAT, the tribunal concludes and the EAT upholds that it wasn't a contract for the provision of work at all, but in fact a contract for the provision of training services by British Cycling to Ms. Varnish. The same in Ms. Quasi's case. It's not a contract for the doing of any work. It's actually a contract whereby she is permitted to attend the premises in order to try and earn money from customers.
Yes.
It is said to have resonance, albeit not on all fours, with a Hong Kong case called Cheng Yuan, which is about a caddy who is permitted to attend a golf course in order to earn money from caddying for golfers. So the next case I was going to take my lords to is White and Troutbeck, but in the Court of Appeal this time. So that's tab 26, page 492, and the reference is at 495. And this is a judgment of Sir John Mummery, as he was, in the Court of Appeal, fairly briefly upholding, for very similar reasons, the judgment of His Honour Judge Richardson in the EAT. This is the caretakers of the farm case. But one sees at 38, the way His Lordship summarised the legal error by...
Sorry, which page is it again?
So apologies, my Lord, it's 495.
495.
This is judgment of the Court of Appeal, Sir John Mummery upholding the decision of His Honour Judge Richardson. Para 38, the legal error at the tribunal's level was in treating the absence of actual day-to-day control as the determinative factor, rather than addressing the cumulative effect of the totality of the provisions in the agreement and all the circumstances of the relationship created by it. And so one sees the focus on the contract and the circumstances of the relationship created by it. And that picks up the language of Lord Justice Elias and Quasi about the employment relationship at paragraph 8. White and Troutbeck was applied in Krista Ackroyd Media. That's in that's in volume 3 of my Lord's Authorities bundle, at tab 40. That's page 876 for the head note. And for the passage in question, it's 893. Paragraph 47. And one just sees the Upper Tribunal applying the language from White and Troutbeck in the Court of Appeal, but emphasising that what it's about is an exercise of contractual construction. And then lastly, in this line of authorities, and I'm sorry for all the jumping about, but it's important, I think, to be chronological. In the supplementary bundle of authorities, at tab 4, the case of Varnish and British Cycling, so page 35 for the head note. And the passage I want to show, my Lord, is at paragraph 34 on page 52. And I believe I read this to my Lords earlier, but just to emphasise it in this context. About halfway down paragraph 34, His Lordship Mr. Justice Chowdhury emphasises the third limb of the test, under which the Court or Tribunal is required to consider whether the other provisions of the contract are consistent, requires an assessment of the entirety of the contract and the obligations thereunder in order to determine its nature. And then to similar effect at paragraph 49, on bundle page 58, His Lordship notes the, as it were, evolving nature of what might be meant by work or service, and says just above C, the constantly evolving nature of what is regarded as amounting to work or service would probably make any attempt at statutory definition impossible, or at least liable to be quickly outmoded. Not all work will be of the kind that gives rise to an employment relationship, for example, a student. It is left to the tribunal, having found that there is a contract, consider all the relevant factors, including the nature of the work done, and assess whether the contract is done a service or not. The task, evidence and ready-mix concrete, whereby, under the third limb of the test, it is necessary to consider whether the other provisions of the contract are inconsistent with its being a contract of service. And so what I seek to do by emphasising that consistent line of authority, my Lords, is to emphasise that what ready-mix concrete is directing one's attention to at the third stage is the content of the contract. And that helps one to identify, one way or another, whether it's properly to be regarded as a contract of service or something else. I briefly want to make a point, just by way of anticipatory response to an argument raised by my learned friend's submissions, where it's suggested that where ready-mix concrete refers to provisions of the contract, that means something other than terms of the contract. I would shortly submit to my lord that plainly doesn't make any sense, given what Mr. Justin McKenna actually said, and given what all the other cases say about the same point, where the words provisions and terms are used synonymously. The next point I want to make at slightly greater length is this submission that there is a need for consistency in this context, as ever, with the essential principles of contractual interpretation. I appreciate that AutoCleanse may be doing something different, although in the light of Uber, that's very much been located in the field of statutory interpretation. But the point about construing the hypothetical contract is that if one is having regard to what's conventionally regarded as factual matrix material, then one is looking at matters which are known or reasonably available to both parties to the contract. And one cannot take into account a fact or circumstance known only to one. The reference, if my lords wanted, for that is Arnold and Britton at paragraph 21, page 555. I'm not going to turn it up, it's Hornbook law. But the point I seek to make in this context, my lords, is that in asking about career history, if one puts that very broadly, if one is asking how can A, if A is the individual, how can A's career history be relevant to the classification of the contract with B, if that career history isn't known or reasonably available to B?
Well, it may depend on what you mean by career history. So in the context of someone like Ms. Adams, where she has a reputation as a performer, her public reputation will be known and reasonably available, but probably not the details of previous contracts.
Quite so, my lord. Quite so. And I'm going to come to this point in a moment, but the reforms to this part of RTPA have, in short, placed an onus on the engager to make a determination of the correct status as between it and the personal service company, with, as it were, the possibility of being liable for the tax if they get it wrong. The engager is going to have to make a judgment about what the classification of their contract is with the personal service company. They can only do so in my submission on the basis of facts which are known or reasonably available to them.
Could I intervene just to check where we are in the structure of your argument?
Yes, of course, my lord.
Just before lunch, you were talking about the nature of the stage 3 exercise.
Yes.
What's going on when the decision maker performs that exercise. What have you been dealing with in terms of headings since we restarted? So
it's all under the...
Is it still under that?
So it's under the general heading of ground 1 of the notice of appeal. What I'm seeking to do is create, I hope, the building blocks for the ultimate submission that the tribunal, Upper Tribunal, fell into error. The first point, as my lord says, was the nature of the exercise at the third stage. The second was focus on the terms of the contract.
Right. So focus. Since we started sitting again, it's been the submission is focus on the terms. Yes.
The third is that there's no distinction between provisions and terms in this context.
So that's a passing point.
Quite so. And the fourth is the need for consistency with the essential principles of contractual interpretation. And just to finish off that point, my lords, I say that the question of factual matrix material and being clear about what is, as it were, generally relevant and what is not, overlaps with the question of the irrelevance of matters of purely subjective intention as a matter of conventional contractual approach, and one sees that instantiated in this context in Christa Ackroyd Media. Just one quick reference for that. It's in the Authorities Bundle, the third volume, at tab 40. And it's page 897. So it's a section starting at paragraph 65, headed Ms. Ackroyd's intentions. And there was a submission that, referring to Ms. Ackroyd's evidence that she would never have entered into the contract if it meant that the BBC would control how she worked. And there was some debate about quite how the first tier had treated that point. But at 68, the Upper Tribunal said this: we consider that for other reasons the Tribunal was right to afford the statement little weight in constructing the hypothetical. And they make the important point they make is, second, the wording of section 49 does not require a consideration of the subjective intentions of the parties prior to the services being provided, but rather an objective consideration of the terms on which the services are provided. So one mustn't focus my submission on what one or other of the parties might subjectively have intended in entering into the arrangement. It's a matter of objective consideration of the terms on which the services are provided. Just for my Lord, note in this context, can I add this point, which I've made already, but it belongs here too, that as to the question of whether the other terms of the contract are consistent or inconsistent, I make no point about that, my Lord, because it's not a matter of substance, but merely of language. The next point I wanted to make is about the situation of simultaneous employment and self-employment. And there are two references here that I can address the point with. The first is fall and pitching, which is Authorities Volume 1, tab 5, page 133, is the head note. So this is the Sadler's Wells dancer. And if I can ask my Lords to turn on to page 142 in the judgment of the Vice-Chancellor Pennycook. At the foot of page 142, following the long quotation from Davis and Braithwaite, there's the old-fashioned language of a post, which is perhaps not of much use, says the Vice-Chancellor. But picking it up from the bottom of the page, Mr. Justice Rowlett, referring to the judge in that case, nowhere says that if an actor enters into a contract in such terms as to amount to what he calls a post, then that actor is not chargeable under Schedule E but Schedule D. On the contrary, it's implicit in the whole of his judgment that if a professional person, whether an actor or anybody else, enters into a contract involving what his lordship called a post, then that person will be chargeable in respect to the income arising from the post under Schedule E, notwithstanding that he is at the same time carrying on his profession, the income of which will be chargeable under Schedule D. The instance of a musician puts that point very neatly. And so just pausing there, his lordship was there making it clear that in order to determine the nature of the engagement, it's important to focus on the contract. It's a quirk of Fall and Hitchin, it's a quirk of Davis and Braithwaite, which my lords may have picked up, that rather oddly HMRC were contending for self-employment and the taxpayer was contending for employment because she'd earned the money in the United States. And at that time, income earned abroad was not taxable. So she wanted it to be employment, and HMRC wanted it to be self-employment. But subject to that, the points of substance carry through. And then further on here on page 29 to page 143 of the bundle, His Lordship said that the word post was perhaps unhelpful.
Sorry, which page is it?
So I'm still on page 143, the same page of Vice Chancellor Pennycook's judgment, my Lord,
Yes.
just picking it up at B,
Yes.
where His Lordship says doesn't think the word post is much use anymore, but he says every word of the judgment is applicable, as between the carrying on of a profession and an engagement in the course of carrying on that profession on the one hand, and a contract of employment on the other hand. The fact that an actor normally undertakes a succession of engagements in the course of that profession in no way involves the result that if an actor enters into an acting employment in the nature of a post, he is not assessable under Schedule E in respect to the income arising from that employment. In other words, there's no necessary inference. There's no inference at all from the fact that
have people who are appearing in productions which run for years, who, although they're actors, may be employees.
it might be, my Lord. It depends on the structure of the arrangements. One might find a company engaged to provide the production, and then that company engages, and those engagements might be employment, the actors to actually make it happen. It's not necessarily a direct arrangement between the theatre and the individuals. And if you like, the example of the musician from Fallen Hitchin, it puts that point. It's obviously needs to be unpacked a little bit, but as I understand the reference, one might find, for example, an individual who, for some of her time, provides private music lessons, and for some of her time performs with an orchestra. And it might be that the fact that she normally engages in work as a music teacher, as a person in self-employment, says nothing about what the nature of her relationship is with the orchestra. It may or may not be an employment, but it's important to focus on the terms of that relationship in order to form a view. And it doesn't matter that it's the same type of work. The actor, the musician, they're all doing similar kinds of work in these examples, but it all depends on the terms of the arrangement. And then a little further on in the same judgment, I think it's the last reference for present purposes, 298 at C. Sorry, the bundle page reference 145. I've been using bundle page references, so apologies for confusion. Bundle page 145, having quoted a passage from a judgment of Lord Evershed, His Lordship goes on to say at C, I've read those passages partly because they show what Justice Rowlett really did decide, and partly because they show that a person carrying on a profession may perfectly well hold an office and also plainly an employment in the same sphere as that in which he carries on his profession. As I say, it all depends on the terms of the arrangement. And there's one final reference on this point, my Lords. It's the case of Synaptech, which my Lords have in Bundle 1 at tab 16. It's page 331. That's the head note. It's an IR35 case involving a computer software engineer with a personal service company. But the important passage is in the judgment of the late Mr. Justice Hart at paragraph 19, page 343.
Before we leave 331, I see at the bottom of that head note, dicta of McKenna J and of Nolan LJ applied.
Indeed so, my Lord.
Yes, where were we going?
I'm going to paragraph 19.
On page,
which is on page 343.
thank you.
And one sees the submission of counsel for the taxpayer, Mr. MacDonald, that once it is established that a person was in business on his own account, that's an extremely powerful pointer to the fact that the particular engagement by the individual is one for services rather than of service. He relied on Davis and Braithwaite. And then picking it up just between E and F, His Lordship says, in my view, nothing in his, Mr. Justice Rowlett's judgment, can be read as authority for the proposition that there is anything like a presumption that any engagement entered into by a person who is in business on his own account is a contract for services rather than a contract of service. Indeed, counsel did not suggest that the evidential burden shifted. And then there's a reference to Vice-Chancellor Pennycook and Fallen Hitchin, approved by the Court of Appeal in Holland Lorimer. And that's the passage I've just shown my Lord. And then at 20, His Lordship went on and said the fact that Synaptic, and notionally the individual, Mr. Stutchbury, was in business on its, or notionally his own account, is no doubt an important contextual circumstance to be taken into account in determining whether this particular notional contract under which Mr. Stutchbury was engaged by the client was one for services or a service, but it is no more than that. Now, I may come back to that question of whether it's an important contextual circumstance, but it's clear His Lordship would not have the proposition that there was any strong inference to be drawn from this.
How does that sit alongside your terms of the agreement being? But if it's an important contextual circumstance, then that's out with the terms of the contract.
Well, that's why I took issue, my Lord, in passing with the word important, because on my submission, it could only be important if one is talking about a pattern of dealings between the same parties, because then it would be a matter within the relevant factual matrix as between the parties to the contract. Whereas if it's a matter outside...
Yeah, but I mean, no doubt Mr. Justice Hart was assuming that. I mean, this isn't a case, is it, where it's suggested that the BBC didn't know what Ms. Adams was doing.
There's no evidence.
Her work with the BBC.
There's no evidence one way or the other.
Well, I think we can infer that they knew a good deal about Ms. Adams and what she was up to, surely. I mean, she wasn't a sort of someone who walked in off the street they knew nothing about.
No, indeed, my Lord, but that doesn't necessarily answer the question.
I suppose not. You mean they didn't know whether she was engaged under contracts of employment or not elsewhere?
They wouldn't necessarily know the terms of any of those other arrangements, my Lord.
So the distinction is they knew full well that she presented loose women, because that was a public fact and part of her public reputation, but they would have had no knowledge of the terms of the contract under which she presented loose women.
That's exactly as I would put it, my Lord.
But I mean, there's an element of unreality here about it, isn't there? I mean, everybody knows that BBC presenters go and do after-dinner speaking or speaking at corporate conferences and so on. I mean, it's a matter of general notoriety. I mean, I don't mean that pejoratively. It's well known. And her contract itself talked about, as we know, there are provisions about what other work she could do and so on. Are you saying that they had in mind other contracts of employment there?
What I'm seeking to submit, my Lord, is that first of all, there is no inference as a matter of law to be drawn from the fact that a person, quote, normally carries on business on her own account, to the proposition that on this occasion she has done so.
Going back to Mr. Justice Hart, do you submit he's wrong in paragraph 20?
Well, what I submit he should be understood as saying in paragraph 20 is that on the premise that is a factual matrix matter as between Mr. Stutchbury and his counterpart.
Yeah, well, I mean,
Then it
that
would
could be suggested by the phraseology, contextual circumstance, in determining whether the particular notional contract. So that might be read, I mean, I'm not sure it's terribly clear, but it might be read as factual matrix, context in that sense.
That's certainly the way I would invite my lords to read it. But
I've lost what your submission on this as actually is. Could we just let you make it? As it were?
Yes.
What do you say?
What I say, my lord, is first of all, reading paragraph 19, His Lordship expressly rejects the proposition that there is anything like a presumption, shall we say, of similarity. That because a person normally enters into contracts for services, so any particular contract should be treated as a contract for services. And I'm going to come back to what the Upper Tribunal did here, but His Lordship...
You say that's what they did.
I do say essentially that's what they did, my lord. But
and as for what Mr. Justice Hart said in paragraph 20, what's your submission?
My submission as to that is that it can only be sensibly understood as it being a potentially relevant factor in understanding the interrelationship between, as it were, the relevant parties, A and B.
Be understood as a potentially relevant factor as between the parties.
So the history of dealing, to instantiate that on the facts, my lord, the history of dealings between Ms. Adams or Atholl House and the BBC may shed some light on the proper approach to be taken to the particular contract at hand. But where in my submission one veers off course as a matter of law is if one says, and the dealings between Ms. Adams or Atholl House and a multitude of third parties
So
are
that's
potentially
irrelevant, are they?
they're irrelevant.
That can't be what Mr. Justice Hart was saying.
Well, in my submission, it's sensibly to be understood as him saying that it's an important contextual circumstance in reference to the contract between here, Mr. Stutchbury, and the notional client, but as in terms of the dealings between Mr. Stutchbury and that client.
Yes, I see.
But you see, the problem, my lord, in my submission is...
supposing the BBC did know a great deal about her dealings with third parties, would that not be contextually relevant in accordance with established principles?
Well, it might be, my lord, to this extent that if that shed some light on what was intended
Yes.
by the particular arrangement that they'd entered into.
Yes.
But it would depend. But we certainly haven't got any focus like that in the first tier in the present case.
Well, I mean, are you saying, is this because there's a, I mean, what I'm trying to get to is whether this is a point of principle or a point of an evidential gap in your submission?
The point here is the Upper Tribunal came up with this test about being in business on one's own
Are you
account.
saying that it is the test? I mean, we're going to look exactly at how the Upper Tribunal did it, and I understand your point derived from paragraph 19. But as a matter of principle, I think what you are saying is that if there have been dealings between someone in the position of Ms. Adams on the one hand and someone in the position of the BBC on the other, then they are relevant and admissible context in the usual sense of contractual principles. I then said, well, what about dealings between someone in the position of Ms. Adams and third parties about which the BBC know or have sufficient knowledge to know how they were done? I'm not quite sure what your answer was on that. Would that be admissible context?
Let me answer the question in two stages, my lord. Admissible, yes. Wait.
Well, sorry, yes, admissible.
Admissible,
They knew
yes.
about it.
I'd accept that it was admissible. Weight, low to minimal.
Well, admissible because it therefore is relevant, because it can't be admitted if it's not relevant. Weight, low to weight is low. It might depend on the circumstances.
It might, my lord, I accept that, what I am assuming, and I appreciate this is an assumption, but it needs to be articulated, is that it will likely shed very little light on what was intended as between the contracting parties, what one of the contracting parties happened to know about the career history of the other. But it might do. I accept my lord's proposition that it might do.
Yes. I mean, more strongly, you no doubt could say in a Hall and Lorimer type case, where you've got a large number of very short-term contracts.
Well, yes, my lord, but I say that the crucial fact there is the lack of any ongoing commitment from one contract to the next.
We'll come to that, but yes, I see. Yeah, okay.
So what I'm going to do, my lords, now is make my submissions by reference to the Upper Tribunal's judgment of where I say they've made their core error here. I'm going to ask my lords to turn
It's a ground one submission.
Apologies, my lord.
Is this a ground one submission?
It is, my lord. This is trying now to draw the threads from the references together and apply them to what the Upper Tribunal did.
Right.
And so it's a reference to the core bundle. Paragraph, so it's bundle page 101, paragraph 79.
Sorry, give me that.
So it's the top of the page, paragraph 79, my lord, page 101. So paragraph 79, so the first few lines are in agreement with HMRC. Any analysis of whether a person is carrying on business on their own account needs to be approached with appropriate rigour, not a matter of accumulating impressions and testing them against preconceived notions. But then this is my submission where it goes wrong. As large as it says 4 lines down, rather the task is to consider at the third ready-mix concrete stage whether the taxpayer's status as a person carrying on business on his or her own account is sufficient to displace, I appreciate my lords don't like this language, the prima facie evaluative conclusion reached following the first 2 stages, that the person is an employee. However, we do not agree that the task can only be performed by reference to the contract whose status is an issue, or evidence relating to the tax years in dispute. And then they give the example of the plumber, which I may come back to. But it's this
was this argued out in front of the Upper Tribunal under any test of carrying business on own account?
The way
or is
in which
that a use of it as simply a surrogate for self-employed?
Well, obviously we had a debate about this point, my lord, along with all the other points. But what we certainly didn't do, and certainly my learned friend didn't invite the Upper Tribunal to do, was to come up with this analysis about starting from the status of a person in business on her own account, and then drawing any kind of inference that necessarily meant that the contract entered into it would be part of that business on own account unless it was sufficiently different.
Well, looking back to paragraph 78, that appears to be the 75. There's a record of an agreement, and that 78 is a record of what the UT thought your submissions were.
Yes, I mean, my submission to that, my lord, is there's a misunderstanding there. What I had submitted to the Upper Tribunal was that Hall and Lorimer and business on own account might best be understood in light of ready-mix concrete and all the subsequent authorities endorsing it as an aspect of what goes into the third stage in terms of testing the question about the effect of the other terms of the arrangement, the employment relationship, if you like, with that concept. As I certainly didn't agree that it may supply a reason in and of itself why the contract was not one of employment. In other words, I accept that these sorts of considerations, and it's important to unpack the phrase business on own account, which I'm going to attempt to do, my lord, but it's important that the sort of considerations that are involved in this context are addressed. And I fully accept that. What I certainly didn't accept, and don't accept before my lords either, is that there is some kind of independent test of being in business on one's own account, what
was intended as a description has morphed into a test.
It appears to be what's happened in this Upper Tribunal
Is
judgment,
that
my
your
lord.
submission?
It is, my lord. It's a very neat way of putting it, if I may say so. I mean, I'm going to show my lords in a moment a particular passage in Mr. Justice Mummery's judgment in Hall and Lorimer, which is worth examination. That what if one looks at paragraph 79, the Upper Tribunal, in my submission, has done? If you look at the last 5 lines as well, if the facts demonstrate that her professional life in both the tax years in dispute and previously involved her carrying on a business on her own account, and if the hypothetical contract with the BBC would be regarded as entered into in the course of that business, that would be perfectly capable of supporting a conclusion that the hypothetical contract was not one of employment.
Which is entirely circular.
Well, I would accept that suggestion, my lord, and I would say that what the Upper Tribunal appear to have done here is to take the language of "in the course of," which to be fair does appear in some of the cases, but without any analysis of meaning, and turn it into a substantive test. In other words, looking for a pattern, looking for normality or regularity, a bit like that phrase is sometimes used in legislation, let's say in the Unfair Contract Terms Act or something like that, where "in the course of" brings with it a sense of normality or regularity. And that appears to be the way in which the Upper Tribunal are using it here in paragraph 79. And really, where the Upper Tribunal go with this is to say, well, once you start with the status of business on account because of career history, then any further engagement said to be similar to that pattern of career history are part of the business on account because they're in the course of the business on account. Now, I make 3 points about that. One, it has got nothing to do with the terms of the hypothetical contract at all. It's based on matters which are either not known or not available to the hypothetical contracting counterparty, or there's simply no evidence about whether they were or weren't known. It's not a test that the First-tier Tribunal investigated by way of application on the evidence. Didn't have it in mind. Nobody could have done. And then they go on at paragraph 86.
So I think you said you had 3 points.
Yes, I apologise.
Sorry, I'm not quite sure what
You're-
3 points.
If I may say so, my Lord's intervention is entirely fair.
Your first one was nothing to do with the
Nothing to do with the terms of the hypothetical contract. The second point is that it has no trace in authority. And the third point is it's actually positively contrary to such authority as there is on the application of the third term. But thank you, my Lord, for making sure I told my court the 3 points. So what I had intended to do, but unsoundly, was to start to develop the first point before telling my Lords the second and third ones.
Oh, I see. Right.
You see the same idea carried through into paragraph 109 on page...
Sorry to interrupt you. I mean, the contract does say, doesn't it, that Miss Adams enters into it as a freelance.
It does.
So there is an express term which refers, but you would say, well, without knowledge of the other engagements she was doing, that really can't amount to anything.
It's an exercise in labelling. As the cases suggest, in a contractual issue, labels can be a kind of tie break at the end, but no more than that, and they tend to have very little weight. In the statutory context, they're simply of no effect. And of course, my lord, it's always necessary to keep in mind that the actual contract is entered into with a company, Atholl House Limited. And obviously we're here in the realm of a hypothetical contract, but what it would look like, it might contain the same label or it might not, my lord, but one's always got to keep in mind the two-stage process under this legislation. So I was going to take, my lord, to paragraph 109 in the Upper Tribunal's judgment, bundle page 108. And they rejected the submission that it was impressionistic for the first tier to have found that Ms. Adams was tending to carry on a profession on her own account. And they said, there's 3 lines down, since the hypothetical contract could be prevented from being an employment contract if Miss Adams entered into it as part of a business carried out on her own account, it was relevant for the tribunal to consider the extent to which she had, either in the tax years in dispute or previously, carried on any such business. And so here one gets a slightly different phrase, sort of in the course of, as part of a business, but it proceeds in my submission from the same misapprehension, that it's right to move from the premise of business on own account to considering whether the particular engagement is in the course of it or is part of it. And then it finds its fullest expression as a new idea, if I may put it like that, at paragraph 112, the same page at the foot. There's a reference to Fallen Hitchin, and the point that I'd shown my lords a moment ago. And then 5 lines up, one has this: it is therefore necessary to consider whether the activities that Ms. Adams performed for the BBC under the hypothetical contract were of the same nature and kind as those that she carried on as an independent contractor. It is also necessary when doing so to consider whether there is some relevant difference between the activities undertaken for the BBC and those performed as an independent contractor.
You say that's way off-piste.
Well, I do say that, my lord, and I say that this is a novel approach, and not in a good way.
Now, to ask this question, no doubt in all of these cases, the putative taxpayer sets out a career history, setting out who they are, what they do, describing their own work position. For what purpose is that done legitimately?
The important word in that sentence, my lord, is legitimately. It is often done to create a sense for a first-tier tribunal which might not have the tests of employment law very clearly in mind, of muddying the waters. It is legitimately done on the premise that it's relevant to consider career history when one comes to focus on the particular engagement.
It would seem quite a strong submission, and I'm just trying to identify how close you are to making it, that history begins on day one of the employment contract. And that really the rest, all the description of my 20-year, 30-year career is really just a lot of window dressing and can have no real relevance. At the moment, I'm just not finding my feet in what your submission is about all of that accumulated information, much of which is likely to be common ground in the sort of cases that we've been dealing with. Is all that just an attempt to hoodwink the first-tier tribunal, or does it have some real significance when coming to consider what the actual agreement was?
In my submission, my lord, it has either no or very little significance when it comes to considering
Again,
what
it's
the
a question of where you draw the line, isn't it? I mean, I find paragraph 110 quite convenient in this respect. So they summarise what Ms. Adams said in her second witness statement, and picking it up in line 4, this included co-presenting the ITV show Loose Swimming. Obviously, that would have been known to the BBC on entering into the relevant contract. It's a public fact, part of her public reputation. Then they go on her evidence, she was paid on a show-by-show basis. No suggestion whatsoever that that would or could have been known to the BBC. So one can, if one applies ordinary principles of contractual construction, it's quite clear where you draw the line. You can draw the line between knowledge of co-presenting the ITV show, which is plainly public and plainly would have been known to the BBC, and being paid on a show-by-show basis, which on its face is utterly inadmissible.
Yes, well, that's a perfectly fair illustration of the point of what should go into the mix and what should not. And the confusion that is caused, in my submission, by starting with the proposition of business on own account and reasoning by stages from there to work out whether the particular engagement in issue before the tax tribunal is part of that business or in the course of that business or sufficiently similar to that business so as to be treated as taxable on the same basis. By looking at it from that angle, one loses sight completely of the terms of the particular engagement that are in issue. And in my submission, why not to start with the terms and work from there. And insofar as factual matrix material like that is admissible, then it may shed some light on what those terms were or what they were understood to mean or what their operation was intended to look like in practice. But subject to that kind of background history, I mean, it may be important to set the scene, and it may be, my lord, I go too far when suggesting anything like hoodwinking. But all I mean to say, my lord, is that it's perfectly legitimate for an individual to tell the tribunal about themselves because they want to explain their position to the tribunal. But as to the question of what light, if any, that sheds on the characterization of the particular contract in issue, in my submission, my lord, it's either outside the frame or it's on the very edges of it at best. It certainly shouldn't be the starting point for working out whether the particular contract is one of employment or not. I would add, just in relation to my Lord Justice Arnold's question a moment ago, that even if the BBC did know the terms on which Ms Adams had contracted with ITV for Loose Women, that might shed very little light indeed, perhaps none, on what the terms of the contract as between the BBC and Ms Adams were intended to achieve.
She's not being paid on a show-by-show basis, but on the contrary, it's a minimum fee of £155,000 for 160 shows.
Quite so, my lord. It's possible one could imagine some facts where a term from an existing contract with another party that both Atholl House and BBC knew about was transposed into a contract because the parties wanted to achieve the same result. And then you could see how what was contained in contract 1 might shed some light on what was intended in contract 2. But I'm getting into the realms of close to fanciful. And just to finish this point, my lords, at paragraph 115 of the Upper Tribunal's judgment, so it's the very next page of the bundle. So this is where the tribunal deals with, the Upper Tribunal deals with the economic dependency point, if I can summarise it like that. And they talk about the instability of the work. And they say 6 lines down, understood in these terms, we do not consider the stability and economic dependence which the hypothetical contract afforded to be inconsistent with a conclusion that it was entered into in the course of Ms Adams's profession as a freelance journalist and broadcaster. And if you like, this is, in my submission, a vivid illustration of how the Upper Tribunal has approached the point from completely the wrong way around, because they are starting from the proposition of in the course of a profession, and now they're looking for factors inconsistent with that. And instead of, as in my submission, they should have been doing, which is looking at the terms of the contract and trying to identify terms of the contract or features of the employment relationship, put broadly, which are inconsistent with the conclusion of employment, or a characterization that the contract was properly to be regarded as employment. And I would just say, by way of addition on the point of financial dependency, just to be clear about this, that in my submission it's important to distinguish between financial dependency that is pure adventitious consequence of the events as they turned out, and financial dependency which is a necessary byproduct of the contract which has been entered into. So if I agree to enter into a full-time contract for all my time for a year, I'm bound to be economically dependent on the person who provides the work, because I'm not allowed to do any other work, because I've committed all my time to this one engager. I appreciate it can be a matter of fact and degree, but that's conceptually different from happening to do 200 shifts on a day-by-day basis without any commitment from one to the next with the same engager that turns out to involve economic dependence. And those are the facts of O'Kelly.
It might be convenient to pick up at this point 115, the penultimate sentence. This is something you mentioned this morning. They say there, HMRC accepted in previous 2 tax years the hypothetical contract was not of employment. See paragraph 3 of the decision. That's not what paragraph 3 of the decision says.
Exactly.
What paragraph 3 of the decision says accurately is that HMRC said they weren't going to oppose the appeal in relation to those 2 tax years.
That's exactly right.
No reason is set out at all.
Well, my Lord is right. Let me just excavate the point for the benefit of all my Lords, that at paragraph 133 of the core bundle, one sees paragraph 3 of the FTT's decision, which is what's referred to here.
It's page 133, is it?
Yes, core bundle 133.
Thank you.
Paragraph 3, the Tribunal notes, this is the First-tier Tribunal, notes that there were originally 4 years in issue, starting with 2014, the year ending 2014, so 2013-14. However, in their skeleton argument of 22nd February 2019, the respondents indicated that they no longer wished to oppose the appeal of the appellant to the extent that it related to the first 2 of those tax years. Now, that is all that the first tier said about the point, but we've put the skeleton itself in the supplementary documents bundle, so my Lords can see exactly what was said. And my Lords will see it at page 53 of the supplementary bundle. I should just emphasise for my Lord's note, in case it causes puzzlement later, that this document isn't in fact dated, but it was submitted on the 22nd of February 2019, hence the date in the Tribunal's judgment.
Paragraph.
And it's paragraph 1.4. What I propose to do is invite my Lords to read that for themselves. So there's no question of my having characterised it in any way.
Oh, right. So, in fact, you said the exact opposite. A respondent remains of the view contracts in question for those years have all the hallmarks of contracts of employment, but you also form the view not an appropriate use of resources.
Exactly.
So it was put in terms that you maintained they were employment contracts. It's the exact opposite of the UT.
I'm afraid so, my Lord. I'm not sure how the Upper Tribunal fell into that misunderstanding, but they did.
I also hadn't until now appreciated that this wasn't shorter periods of work on the same venture, but that it was different ventures, different programs.
Well, I mean, I can assist my lord with this.
But the point only being that I hadn't up until now appreciated that it wasn't that it was the same evidence, but just about a lesser sum. It would have involved going into the other programs and the arrangements under the other programs.
Yeah, there were two earlier contracts. My lords have them, but let me just give you, my lords, the references. For 1314, there was a contract for 200 programs. That's on page 5 of the supplementary bundle. But it was later, in December 2013, reduced to 104. See page 20. And then for the year 2014-15, there was a contract for 45 programs. That's page 23. Then 15-16 was for 160 programs, and 16-17, which my lords don't have in the bundle, but it's absolutely identical to 15-16, also for 160 programs. So my lords, what I would say about this is that, for better or worse, HMRC were trying to be proportionate at first instance in focusing on what it was being said were the years that mattered, if you like, in terms of tax. But it wasn't a concession that years, if you like, 13, 14, and 14, 15 should be treated as business on own account years under the same terms, such that there was an inference to be drawn that the same work under the 15, 16 terms should also be regarded as business on own account. And so when one goes back to the Upper Tribunal's conclusion at 115, paragraph 115, that's core bundle, page 109. The tribunal draw an inference against HMRC on the basis of this misunderstanding about what HMRC said about years 13, 14, and 14, 15, and then concluded that, well, there was nothing new in 15, 16, 16, 17 in terms of economic dependence.
Yeah, so the error at the end of 115 is carried through into 116.
It is, my lord. I mean, the overall picture was, in fact, that there had been a history of contracting between Atholl House and the BBC from 2010. So that the 2015-16 contract, which was the first of the two in issue, was year 6 in a pattern of contracting. And you get that 2010 chronology from the first year's judgment at paragraph 57b, that's page 160. I'm not asking my lords to turn it up, just for note. So in my submission, my lords, on ground one...
But these were the early ones. I mean, did the legislation change over this period?
No.
So the early contracts, there wasn't a challenge, if you like, by HMRC to them.
Well, there originally was. HMRC had originally issued decisions and notices of determination.
In respect of?
In respect of... Oh, I'm sorry, if my lord is from 2010...
You say contracts go back to 2010, so the first assessments, if you like, were in respect of 2014, 15 and 2015, 16.
The 13-14 year was the first one originally assessed.
Yes.
HMRC were out of time to pick up anything earlier than that.
I see.
By the time they got round to, as it were,
so looking at
finding this case as one to be considered.
Yes, I see.
They then, as it were, in their skeleton argument for the FTT,
no, I see.
Dropped the opposition to 13,
Yes.
14 and 14,
I was just
15.
asking about the early ones.
Yes. But it wasn't on the premise that there was a concession that they were not to be regarded as contracts of employment, as my Lord Justice Arnold says, the very opposite.
And nothing was said to the Upper Tribunal in the course of submissions about this?
I don't believe it was, my lord. I certainly can't recall it. I mean, there's a point in my learned friend's written submissions where they suggest that the contention that this was not a concession was implausible, but I can only think that when that was written, the person writing it didn't have in mind what was actually said in HMRC's skeleton for the FTT, because it's written in black and white terms what the premise of HMRC's approach was.
Yes.
So, my lords, I'm going to move on, if I may. I'm conscious of the time, but I think I can be relatively more economical on ground 2, having covered a lot of the ground on ground 1. The references from my lord in terms of the skeleton, paragraphs 33 to 46, that's core bundle, page 26 to 31. And the premise, my lords, of these submissions, which is, if you like, a contentious premise from my perspective, is that the tribunal, the Upper Tribunal, was correct to treat the business on account test at the third stage as having some kind of independent life of its own. So contrary to my submission that it doesn't belong in the analysis like that, let's assume that it does. And I say there are further errors on that premise that the Upper Tribunal made in asking generally whether Ms. Adams was in business on her own account, rather than focusing on the terms of the particular engagements. And secondly, and separately, in failing to take into account the conventional considerations at this point about what can be put in terms of shorthand economic reality, financial risk, equipment, helpers, those sorts of considerations. And I just wanted to show my lords some consideration in the cases about business on own account. I'm going to be economical about this and just deal with the most important ones. In the first authorities bundle at tab 8, the case of Nethermere, these were the home working clothing pieceworkers being paid by item of clothing that they made. There's a passage in Lord Justice Dillon's judgment of some note at paragraph, so it's bundle page 214. From the very top of the page in Lord Justice Dillon's judgment, he refers to the Industrial Tribunal's treatment as the fundamental test as being whether the person was in business on his own account. And that was taken from market investigations. He says, between B and C, I do not therefore suggest that the tribunal misdirected itself in seeking to apply such a test. But then picking it up after airfix at C, I do, however, for my part, find the use of the word fundamental somewhat misleading. In some cases, such as jobbing gardener, carpenter, or music teacher, who is found to be carrying on the activities for several customers or clients as part of his or her own business, the test may be very helpful indeed. But in many other cases, the answer to the question whether the person concerned is carrying on business on his or her own account can only come as the corollary of the answer to the question whether he or she was employed under a contract of service. So what you see there very much, my lord, is an instance of it being deployed as a conclusive descriptor rather than as containing any kind of internal analytical content. And then I promised this a couple of times, I'm going to deal with it now. In Hall and Lorimer in the High Court, so that's bundle 1, tab 10, reference page 244, please, to the judgment of Mr. Justice Mummery, as he was. This is on appeal from the Special Commissioner, the equivalent at that point of the First-tier Tribunal. And Mr. Justice Mummery was sitting as the equivalent of the Upper Tribunal. There is a passage beginning at J, which is of some importance because it indicates His Lordship's approval of Mr. Justice Cook in market investigations, because Lee Ting Sang, the Privy Council, had said so. It's just worth noting in passing, although perhaps only for historical interest, that counsel for HMRC and Lee Ting Sang positively put forward market investigations as the right test. But it's the passage beginning at 612, just the first complete paragraph on the page, so bundle page 245, in order to decide whether a person carries on business on his own account, it's necessary to consider the many different aspects of that person's work activity. Now, this is the passage that's specifically quoted and approved in the Court of Appeal, down to the citation from Rawls and Sinnott. But then, and this is the nub, at E to G, one has this passage, which isn't specifically approved, and so far as researchers have indicated, has never actually been substantively considered by another judge sitting in an appellate capacity. The decided cases give clear guidance.
You want us to read this entire paragraph?
I would be grateful, my lord, yes, from E down to the end of the paragraph between G and H. Thank you, my lord.
Right.
So, I want to bring out three separate points. The first two are short. The first point is, one can see from this list that it includes, as the first two items, rights and duties and control. So they're not identified here as separate requirements, but as part of a list of potentially relevant elements. So first point is, that's not the same approach as ready-mix concrete. It is treating those two features as something different. As to the first of them, express or implied rights and duties of the parties, what that doesn't capture in the way that ready-mix concrete does is the sense in which there needs to be the wage-work bargain, as Mr. Justice Langstaff summarises it in Cotswold, which I think my lords have seen, or the obligation of personal service.
The way ready-mix concrete is brought into this is on the previous page, isn't it, at letter H. Simply by reference to what were then thought to be leading authorities.
Quite so
which the judge then goes on to get to work on.
Exactly, my lord. But he moves on to the factors, if you like, on the premise that the right approach is market investigations, Lee Ting Sang, and you put everything together in a list. And certainly in light of Montgomery, that particular aspect of this passage can no longer be treated as right. Of putting...
Which aspect?
Of putting the express or implied rights and duties of the parties in control into an undifferentiated list.
Well, particularly control, I suppose.
Well, both, my lord, because ready-mix concrete, as upheld in Montgomery and subsequently, requires the relevant mutuality and sufficient control to be established as preconditions.
Well, I see
Right, so this is
and it's important
too, and Montgomery's 2001. 1992, 2001.
Yes.
Yes.
Yes, of course, my Lord. Montgomery is subsequent, of course. I mean, I'm not purporting to criticise Mr. Justice Mummery for failing to apply a case he couldn't have known about unless he'd been reading H.G. Wells. But the point here, my Lord, is that just by way of context, the way it was argued and dealt with in front of the Special Commissioner was the business on own account test. And he wasn't asked to and didn't apply ready-mix concrete. And so the issue for Sir John Mummery is sitting in the, Mr. Justice Mummery as he was then, sitting in the High Court, was to consider whether the Special Commissioner had erred in his application of the business on own account test. Just to be clear about the context. But I just wanted to now, secondly, expand on the point about degree of control, because the language that Mr. Justice Mummery there uses, degree of control exercised over the person doing the work, certainly isn't how it's put in ready-mix concrete or subsequent cases, which is all about the power of control rather than degree of control exercised. In other words, it's about rights rather than about practicalities. And Mr. Justice Langstaff makes that very clear in Right and Aegis, referring to the whole history of authorities up to that point.
There's a peculiarity which I think we noticed last week, that in Montgomery, Hall and Lorimer was cited in argument, but is not referred to in the judgments.
Quite. And one sees that pattern, and I appreciate my Lord has it very much in mind, in many of these cases where, as it were, as time moves on, particularly in the employment cases, in other words, the cases that start in the employment tribunal, one sees reference in the appellate cases to ready-mix concrete, but not to Hall and Lorimer. And there is something, I can't say how far I can put this point, my Lord, but there is something of perhaps a lack of, well, let me put it like this, a kind of silo effect, where the tax cases are cited in the tax tribunal, and the employment cases are cited in the employment tribunal, and they don't necessarily come together.
They pass each other by.
Quite so, my Lord.
Sometimes.
Quite so. Not always. So, for example, in Mr. Justice Chowdhury's recent judgment in Varnish, he has both of them in mind. So where you have a judge like that sitting as the president of the tribunal, he very much has the fullness of the authority in mind. And then just lastly on this list in Mr. Justice Mummery's judgment, one sees the sort of features that have been mentioned in prior cases, like market investigations and Lee Teng Sang, picking it up from 5 lines down, provision of own equipment and the nature of that equipment, staff, financial risk, responsibility for investment and management, and so on. I mean, my lords have read this, but these are the sort of conventional features that have tended to be looked at the third stage.
Yeah.
But they're all features of the contractual relationship, either deriving from the terms or from the effect of the terms.
So when we're looking at this paragraph, is your submission basically to point out that it doesn't have the structure of the RMC test that you say is the right structure, and that if one was to take off the top of it, the 2 first conditions, then were you making criticism of, in principle, of any of the other matters as being matters that might come into the equation when considering the third stage?
The one matter I would draw out in answer to that question, my lord, is directly against G.
Yes.
How many engagements he performs, and whether they are performed mainly for one person or for a number of different people. I would say that's potentially misleading. I understand why Mr. Justice Mummery highlighted it on the facts of Hall and Lorimer, given that that was the fact pattern. Many hundreds of individual short-term engagements over the years in question.
But with that, Tamara, in general, your point is about the structure of the decision-making rather than the small detail of the points that are thrown up as potentially relevant.
It's twofold, my lord, structure and different treatment of the question of rights and obligations and control. So it's not just about structure, that's one aspect. And the second aspect is that it actually involves a different substantive approach to the questions of the effect of the contract, number one, and number two, the question of control. Should it be about rights of control or should it be about exercise of control?
But also, Mr. Justice Mummery seemed to think it was relevant to consider the intentions of the parties, whereas on your submission that's irrelevant because it's inadmissible.
Well, only insofar as they are expressed in the contract, my lord. So you can say, as a matter of metaphorical language when arguing about contractual construction, what does the contract tell you about the intentions of the parties? But that's just a way of speaking in terms of
So
expressing
if
the
it's a question
idea.
of their intention as objectively manifested in the language of the contract, fine, but not their subjective intentions.
Quite so, my lord. I wanted to.
We don't know whether he's talking about a case where you've got a complete written contract.
Well, he definitely isn't, my lord, because on the facts of Hull and Lorimer, there was no written contract at all.
Well, shared understandings and intentions might then be relevant in determining the terms of the contract.
But the important word would be shared, my lord.
Sure, I'm sure. Yes, of course. Of course.
Because
But he says understanding and intentions of the parties, not of each of the parties. I mean, it naturally reads of both parties.
Well,
anyway, it doesn't much matter, but the point, I mean, it would in that context be relevant to determining the relationship, the contractual relationship.
that's fair, my lord. For your lordship's note, at page 243 of the printed bundle, at F, one sees the note that there were no formal written conditions of engagement.
Thank you. I hadn't picked that up, thank you.
So, my lord, it's on bundle page 243. In summarising the facts, just against F, there are F on page 243. There are, however, no formal written conditions of engagement.
Yes, thank you.
So, perhaps in that context, I see the force of my lord's point that when Mr. Justice Mummery is referring to understanding or intentions, he may very much have in mind that there was nothing in writing. Then in Hull and Lorimer, in the Court of Appeal, so that's volume 1, tab 11, page 257. The passage I'd seek to draw to my lord's particular attention is from B down to the end of E. Maybe my lords have already read this in the course of the hearing last week, but can I ask my lords to briefly reread it?
This is the case which cites market investigations, and although they were told about RMC, it doesn't cite it.
Yes.
Page, sorry.
So it's bundle page 257, my lord.
Thank you.
Paragraph beginning again the question. Just that full paragraph, if I may. If I can ask the court to read that.
Yeah, well, as we noted last week, this suggests that the test of business on own account is of little assistance when dealing with people carrying on a professional vocation.
Because they may have few of the trappings, as it's put, of a business. But I'm not quite sure what his lordship had in mind in terms of the phrase trappings of a business. But
like an office, for example. I mean, nowadays, of course, our view on working from home is rather different.
yes, quite, my lord. It may be that kind of distinction no longer carries the weight it once might have done. But he does their focus, his lordship, Lord Justice Nolan, does their focus on dependency and duration and number of people by whom the individual is engaged. I would suggest those are very much products of the facts of Holland Lorimer. But I would emphasise this, if I may, that, and I'm conscious I'm repeating myself, but in my submission it's important to keep in mind what's a matter of mere chance and what's actually the result of the contract that's been entered into. So that if Mr. Lorimer had turned out to do 80% of his engagements for one client, that wouldn't really tell you anything useful about the individual contracts between Mr. Lorimer and that client, unless there was some commitment involved in the contract entered into between Mr. Lorimer and the client for that amount of work. If it just so happens, looking back on the year in question, that's how things turned out, then financial dependency in that sense may have very little to commend itself as a feature in ascertaining whether the terms of any individual contract between Mr. Lorimer and the client was one of employment. But the most outstanding feature is the working for very many clients and most of them extremely short. And that's the key point, my lords, that out of each contract between Mr. Lorimer and a client, one can't extrapolate very much, because there's no ongoing commitment involved of any kind. I just wanted to pick up one theme in the cases which I've referred to already, and my Lord Sir David Richards asked about it. It's the so-called economic reality test, which was summarised, as I showed my Lords, by Lord Justice Lyson Quasi as synonymous with the business on own account test. And just if I can help my Lords, where it comes from and where it goes, if we pick it up in bundle 1 of the authorities, in Ready Mix Concrete itself, so that's tab 3, and it's page 101 in the printed volume. You see at the foot of page 101 a reference to a Canadian decision, which ends up in the Privy Council, opinion of Lord Wright in Montreal and Montreal Locomotive Works. And very different context, all about occupation of an armaments factory and liability to certain taxes as a result. But you can see on the next page, on page 102, a quotation taken from Professor Attia's book, or perhaps he was only Mr. Attia at the time, and then cited by Mr. Justice McKenna from B to E. But can I just ask my Lords to look at the passage from D to E, and in particular the final sentence. It is in some cases possible to decide the issue by raising as the crucial question, whose business is it? Or in other words, by asking whether the party is carrying on the business in the sense of carrying it on for himself or his own behalf and not merely for a superior. That was the way it was put there. And that's referenced, I'll pass over this, but just give my Lord a note, by Mr. Justice Cook in Market Investigations, see page 128. But the important point I was going to pick up was from Lane, because it was a matter Lord Sir David Richards asked about.
What was the reference in Market Investigations?
So Market Investigations is page 128.
That's where we'll find the reference.
Yes. Let me just check to make sure that that's right, yes, my Lord, because I'm being very quick about it. But yes, 128 is where you'll find it.
Yes, yes.
But I was going to move quickly on to Lane,
yes, which
is in the Supplementary Authorities bundle, tab 1, and my Lord asked me about this earlier.
Yes.
It's page 5. I should probably start at the foot of page 4. So as my Lord noted, 15 and 16 set up a variety of possible analyses. 16 refers to control. And then 17, going on to the next page, control test may not be decisive. In such cases, His Lordship went on, this is Lord Justice Henry, the question is broadened to whose business was it? Was the workman carrying on his own business, or was he carrying on that of his employers? And that's reference to the American case of Silk, whether the men were employees as a matter of economic reality. And he says that might cover some of the same ground as control, although I'm not quite sure about the example he gives. But he then says that may involve looking to see where the financial risk lies, and whether and how far he has an opportunity of profiting from sound management in the performance of the task. See market investigations. I mean, there may be an exercise in just labelling, and there may be an exercise in substance. But as a matter of conclusion at 23, having referred to what the judge at first instance had decided in concluding that Mr. Lane was not an employee, His Lordship says, well, all of those reasons would apply equally if the work were being done under a short-term single job contract of employment. All of them concentrate on what Mr. Whittaker, he was the principal of Shire Roofing, wanted, and not on whose business it was. And then there's an analysis about the so-called lump in terms of that metaphor for day-to-day contracting. But he ultimately says, when you ask the question, whose business was it in relation to this particular job at this household fixing the roof, it could only, in my judgment, be answered by saying it was the respondent's business and not the appellant's. So it's again a kind of form of stating the conclusion rather than underlying analysis. But it was thought in these cases to shed some light on the same sort of factors as are caught by the business on own account test. Just another way of looking at it, perhaps. But what I would say by way of submission, my lords, that in none of these authorities is there any support for any kind of comparative analysis, as the Upper Tribunal carried out here, as between the type of work done under the particular contract in issue with the type of work done under other engagements. Nor is there any support for an inference being drawn that work of the same nature should be regarded as entered into in the same way. And in this context, I repeat what I've said about Fall and Synaptic, that in fact that's contrary. That approach is contrary to those authorities. And indeed, when one comes to the relevant part of the Upper Tribunal's judgment, its approach led it to overlook the normally important features that one has regard to, such as duration of engagements, level of work commitment, and the other factors which are perhaps negative in a case like this: provision of equipment, hiring of helpers, degree of financial risk, all those sorts of points. In other words, you don't get that analysis in the Upper Tribunal's judgment at all. It's just missing because of the way they approached the business on own account point. And so, my lords, I made some of these submissions in our skeleton argument, but I just wanted to briefly summarise them. That some of the potentially consequential problems arising from the Upper Tribunal's approach, which in my submission are contrary, as it were, to sound legal policy in this and other related fields of trying to identify a contract of employment or not, is first of all, it's likely to undermine the clarity, the need for clarity of structure and consistency. In other words, if you start getting involved in debates about how similar or otherwise one job is with another, and whether it's really of the same type and to what degree, one's likely in my submission to end up in something of a mess. There's a second point about complexity and expense, which is if you do have to investigate a person's status as a matter of their entire career, that could potentially be a very involved exercise. Because one can't necessarily take it at face value. If it's going to be a highly material consideration for investigation at the third stage of ready-mix concrete, then there's going to need to be, for example, disclosure of all the contracts that were entered into in the relevant period, so that one can test whether each of them should properly analysed, be treated as a contract of employment or not. And that will obviously increase the expense of the exercise. And as we make clear in our submissions, that's certainly not the way that employment tribunals normally approach issues of employment status.
Wouldn't all this really just be available from their tax returns? So their Schedule E tax would be set out, and their Schedule D tax, the revenue would have accounts to support the Schedule D profits or losses.
Well, one wouldn't,
unless you were going to reopen, which might be too late to do. I mean, wouldn't that provide an answer here?
well, it wouldn't necessarily, my lord, or it would certainly only be superficial, because one wouldn't be able to go behind the...
Why would you want to go?
Well, you might be... In a case where it was now being said to be important...
It is important in your tax return.
But it made, the tax return...
I mean, if you're not going to say, are you, well, that was put in as Schedule D income 3 years ago, it should have been Schedule E.
Well, one might, my lord, if it becomes important.
I mean, then you should have.
But on a self-assessment basis, my lord, HMRC are entitled to open an investigation and to make an inquiry about it. And if it's not accepted that the Schedule D treatment is correct, to issue, as happened here,
a
notice of assessment.
Of course, and then it's all in. I agree.
All I'm saying is, my lord, it can happen. It can happen.
You're sort of dangling, sort of more. I mean, I can't believe really it's going to be that difficult.
Well, it turns...
These things are normally reasonably obvious. And as I say, if they're not, then the taxpayers' tax returns would provide much of the information, I would have thought.
Well, no, my lord, it would just be a number in the relevant box. It wouldn't tell you anything.
You'd have the accounts to support it.
But you wouldn't have the contract terms.
No, but...
But the accounts may have been mistaken, my lord. The accounts are prepared by either the taxpayer itself or somebody acting for the taxpayer, and without imputing any nefarious motive whatever, they may just be wrong in treating it as Schedule D.
Right. Well, I mean, the submission is really that the
You've got
more
to wait for
information
everything.
that you're entitled to take into account, the more expense it may take to gather it. I mean, insofar as it's an in terrorem submission, I'm not sure that that's what you're really seriously trying to...
It's not in terrorem, my lord. It's a question of what's relevant. If it isn't relevant, then one really shouldn't be taking it into account in the first place.
Yes.
If it is relevant...
If it is relevant, then tough.
I accept that, my lord.
All right.
And the last point I wanted to make, my lord, in this context is that the relevant legislation was reformed in stages in each of 2017 and 2021 so as to create an onus on the engager to determine the correct status of the person with
How
whom they're
can
dealing.
that be relevant when it postdates the tax years in question?
It's only to this extent, my lord, that if the Upper Tribunal's approach were taken as correct as a matter of premise, that one is entitled to have regard to the whole of the, and indeed one should have regard to the career history, up to the point of contracting with the relevant engager, then that would be true henceforth, as it were, as a matter of law, in terms of working out how these provisions of ITPA were meant to operate in practice. In other words...
I still don't understand how we can apply subsequent legislation to the tax years in question.
My lords plainly can't apply subsequent legislation to the tax years in question. All I mean to say is it's one of the potential consequences to be considered of the Upper Tribunal's premise.
I didn't write down what you said the essence of the change is.
The essence of the change, my lord, in 2017 was in relation to public authorities, and in 2021 in relation to medium-sized and large companies, by reference to the well-understood definition of what's a small company, that in those circumstances, there is an onus, to put it in shorthand form, on the engager person providing the work, to determine the correct status of the person doing the work. In other words, they have to form a view about whether PAYE should be deducted at source. And if they get that wrong, then they may ultimately be liable for the tax that should have been deducted at source. So whereas in the years in question, and I accept my Lord Lordship's point, whereas in the years in question, the risk of getting it wrong falls on the individual who was the principal behind the personal service company. In the new regime, that risk is transferred to the person
so that
providing the
effectively,
work.
as I understand it, is for our information.
Yes.
The decision that we make may be read in a context in which the legislation has moved on in those respects.
That's perfectly fair, and I accept that.
Right. It doesn't push one way or another.
Thank you, my Lord. So the final point here is that on the facts, none of these factors was taken into account by the Upper Tribunal, all of which are apparent on the authorities as at least potentially relevant.
Right.
And these are the factors. There are 5 of them that are matter in my submission. Financial risk. In other words, on the facts of this case, I submit that there was no financial risk undertaken by Ms. Adams in the hypothetical contract, other than the same sort of risks that any employee might face.
Right. Next point.
No material equipment provided.
Yes.
Third point, no hiring of helpers. In other words, the contract doesn't require it or involve it.
Yes.
Fourth point, no responsibility for investment or management. And fifth point, no realistic opportunity to profit from sound management and the performance of the tasks. So those are the factors that the Upper Tribunal wholly left out of account. So in my submission, what I invite my lords to do is to find the errors of law that I've sought to identify in the Upper Tribunal's approach, to identify the correct tests, and apply them correctly. But if my lords are against me on actually applying the tests, then it may be that the only alternative is a remission to the tribunal.
Right, let's just work through this. Let's start with, from your point of view, the happy prospect of you succeeding on both grounds. What do you then say that we should remake the decision ourselves?
I say that your lordships can and should remake the decision yourselves, because the answer is clear in this case.
Right, and that's paragraph 47, the last page of your skeleton.
It is, my lord. But if your lordships are against me on that, and I'm conscious...
Just a second.
I apologise.
Right, so success on both grounds, remake. Right, next.
But if your lordships were against me on that, in other words, that your lordships were, I acknowledge...
No, but I'm just going through the success on trying to work out what the consequences from your perspective are of you succeeding on one ground but not the other.
I say the same outcome arises, my lord, because when one applies the right test, either on my ground 1 point or on my ground 2 point, in my submission the outcome is clear, because the relevant contracts involve the requisite elements, and there aren't any terms inconsistent.
In what circumstances would we have to remit?
That your lordships were not satisfied that they had sufficient factual material
right.
Okay.
from the FTT to remake the decision themselves.
We would be making it in reality as a first instance court, because both on this hypothesis, neither of the evaluations by the First-tier Tribunal or the Upper Tribunal stand. So, I mean, we would have to be, is this right? Pretty sure what we knew the answer was.
Yes.
We thought, because we haven't heard argument from you really,
Well,
on this issue. We haven't heard argument. I'm not quite sure there's very much in your skeleton.
the last page of the skeleton, paragraph 47, as my lord rightly says, addresses this point.
No. What it doesn't argue, it doesn't set out the arguments for saying this is a contract of employment. What you've done you've spent the day quite rightly shooting down what the Upper Tribunal has done, but that clears the ground for a contest as to what the result should be in relation to these two contracts,
Yes.
on which I don't think there's very much in your skeleton, is there? I don't know, and we have had no oral submissions.
Well, I'm certainly not taking that at this point in the day, having gone beyond my estimate by an hour to start addressing the court on
I mean,
that
you
subject.
understand the point. That
I do
we're
understand.
being asked to decide a point as a court of, effectively as a first instance court. Now, you may say, it would say blindingly obvious that there's no need to hear any arguments from anybody.
Well, I understand my Lord's point entirely, and I'm conscious, and we refer to this in our skeleton. There's a case called Newey involving a decision of Lord Justice Henderson, who might be said to know what he's talking about in this field. And he certainly indicates that the Court of Appeal should be cautious before exercising its undoubted statutory power to remake a decision on appeal from the Upper Tribunal. So I acknowledge that point.
You say we should, I understand that.
I do say that you can and you should, but if my Lords are against me, what I say by way of alternative is that the right course is a remission. So I'm very grateful to my Lords for listening to me for essentially a whole day. And unless my Lords have anything further, those are the submissions I'd like to make.
Mr. Tolley, thank you very much indeed.
Thank you, my Lord.
Yes, now, Mr. Gordon, don't approach this on the basis that the day has come to an end. Far from it. It's from the point of view of your client's case, the sun is just rising. So we'll sit until past, so that, as it were, we don't stop just as soon as you've warmed up. So if you'd like to decide how you want to spend the 40 minutes now, and compress it into that,
I'm waiting for that, my Lord. To make these, what I propose to do, and I think, given that we are rising at about 4:30, I think I can carry on with my original plan, was to divide my submissions into 3 broad sections. The first, to be to spend about 10 minutes going into this case at a very high level, just summarising our position. Now, given the exchange we've had a few moments ago about remission, it might be that some of the submissions I make will be inappropriate, because if I can just nevertheless have that 10 minutes just to give a high-level overview of our case. The second section, which I will obviously be able to start this afternoon, is to address the appellant's 2 grounds of appeal, to respond to those. Before my final stage will be making good our alternative reasons as to why this appeal should be dismissed. But just as a foretaste, addressing the appellant's 2 grounds of appeal, what I will be doing, and I might aim to complete the process today, I might not, is to canter through all the authorities to make good our main proposition that Paul Anonyma is an implicit part of the ready-mix concrete strand of cases. It's not in contest with it, it's not in conflict, it is a natural implementation on the facts of the case, and the principles discussed therein are fully applicable to all cases, including the present. That's just a bit of form. Going to my high-level submissions, it's common ground how the IR35 rules operate, and the parties are agreed that paragraph 6 of the Upper Tribunal's decision sets out the approach to be taken to section 49 of the 2003 Act. But I do want to emphasise one point, which is definitely common ground, but there was a bit of tension this morning when my learned friend put his submissions. Once one has identified the hypothetical contract, the normal common law tests of employment status are engaged. It is not as if the IR35 context brings non-employment relationships into the sphere of employment taxes, or vice versa. In other words, the question of purposive interpretation is, with respect, irrelevant. Once one has identified the hypothetical contracts, this is a straightforward common law test used both in the employment tribunals and the tax tribunals and elsewhere as to employment status. On this high-level overview of the case, I do wish to remind the court of the principal facts that must be taken into account when considering Ms. Adams' employment status under the hypothetical contracts. Now, I can either take the court to the actual passages or just give you flags.
We'll start with references and see how we go.
So the first is the unchallenged finding of fact of the first tier, paragraph 6, core bundle, page 134. That discusses the wider self-employment going on, or the wider business. As I expand my submissions, I will maintain that is a very important consideration. The profession is carried on through the medium of the respondent company. So if I can just on that point pick up something my Lord Sir David Richards had said earlier this morning, the business, the wider business, is carried on through the company. There is no self-employment in the true sense of the word. But it is the company's business, which includes the BBC contracts as well as the other manifestations of the profession. I would like to highlight the tribunal summary of the evidence, again the first tier, 57J, core bundle 161. Just highlight the fact that in the years in question, Ms. Adams did not provide her services on the full number of 160 days as specified in the written terms. You see that at 57G. And I also suggest it's illustrative to see how the BBC themselves described Ms. Adams. If I could ask the tribunal to turn to page 163 of the core bundle. At 58 paragraph B, so it's halfway down the page, the latter half of the paragraph.
I beg your pardon, could you give me the page again?
Do it, my lord, it's page 163.
Thank you.
Mr. Patterson was one of HMRC's witnesses. And 5 lines up from the bottom of the paragraph, Mr. Patterson had likened Ms. Adams to the conductor of her orchestra. That note, this was at a meeting which the Revenue had with the BBC, including the BBC's own legal team present. That note also recorded Mr. Patterson as having said at the meeting that Ms. Adams was very much a broadcaster in her own right, and given that she works for others, she isn't BBC's Kaye Adams. She's a journalist who happens to work for us. And allied with this, I remind the court what the first tier concluded at paragraph 108, which is paragraph, so page 177 of the core bundle.
I'm just pausing over the expression, a journalist who happens to work for us, contains all manner of
Indeed, but in the same way,
interesting thoughts. But anyhow, on you go.
My lord, one can look and see the word employment used in the non, if I can use the old terminology, Schedule E sense.
Right, where are we going next?
It was page 108. Sorry, paragraph 108 of the first tier's decision, page 177 of the core bundle. So these are just the highlighting paragraphs which I would consider a part of the factual matrix that any fact-finding tribunal should correctly consider. It is our case that the work with BBC Scotland was merely one element, or one incident, as some cases call it, of this wider business. Ms. Adams, through her company, was engaged to provide her services to the BBC in a series of contracts over a number of years. Each contract was discrete, no commitment on either side to renew, and there wasn't even a joint commitment to renegotiate at the end of each term.
Which paragraph are you particularly looking at, 108?
No, I'm now moving on, just making general submissions about the contract.
The duration of each contract was typically around about a year.
Indeed. So longer than Mr. Lorimer's, undoubtedly. But we say that that year, the duration is a factor to take into account. It doesn't suddenly put one in the realm of employment. And the example that we put in our skeleton argument, and I will no doubt repeat tomorrow, if, hypothetically, Dame Judi Dench were engaged by Cameron Mackintosh to appear in the Scottish play for a year in the West End, the natural consequence of my learned friend's arguments are that that will be an employment.
Well, it might be. It all depends on the terms of the contract. That's the problem with all these hypotheticals is it always depends on the particularities.
Indeed.
I mean, if one takes a slightly different theatrical example, Les Miserables, for example, well, that was running, I can't remember if it's back yet, but you know, that was a long-running show, and probably quite a lot of the people in that show were employees, at a guess.
Absolutely. And this is almost the distinction between the Davis and Braithwaite Authority and Fall and Hitchin. But if, as I said, I'll have to expand upon it in due course, but the natural consequence of my learned friend's submission is that you look solely at this contract, even though it is quite clearly an incident of one's self-employment. My learned friend will be urging this court to say it's employment, and I say that that is clearly wrong. You've been taken very briefly to, and our skeleton argument also makes reference to the different contracts over the time. That each contract had a different commitment. Your Justice Arnold is indeed correct that on the whole the contracts were for year to year, no doubt for BBC planning purposes. But it's also worth noting that the name of the programme changed each time. These were different contracts. And if the BBC should say, actually, we no longer want this voice at that time, then there'll be no future contracts. Does the court want me to take you to the actual detailed contracts historically, or is the reference in the skeleton argument sufficient?
Well, perhaps give us the reference in the skeleton argument, and then...
Paragraph 38 of our skeleton. And there are references to the supplementary bundle.
Just a moment.
But as David Richards made clear, was it that these contracts do emphasise that they are freelance. As to what weight one gives to it, that's another matter. But certainly intentions of the parties were that these were for the freelance services.
Right, so we're in paragraph 38, and your very helpful marginal box
Indeed.
Refers to the terms that you're relying on.
Absolutely. Mainly highlighting the different durations, number of programmes, each contract, based upon the written terms. We say that such fluctuations are typical of the work of the self-employed. These fluctuations sometimes come by choice, sometimes by circumstance, sometimes a combination of the two. And the first tier explained why the number of days increased in 2015 at the time, the beginning of the period that this court is particularly focused on. And the reference is paragraph 57Q of the first tier's decision, H162 of the core bundle. But this was Ms. Adams wanting to spend greater time in Glasgow, family reasons. But it's worth noting that even in those years, and we can see the reference at page 177, paragraph 112, that even in those years, at most, it was 70% of the company's income coming from the BBC contract. So we're not talking about it drowning out exclusively. One's employment status does not change simply because one takes a bigger commitment for a period of time, or even if the percentage of earnings from one source passes any particular threshold. And again, I will use the example of an actor, but it could equally be a barrister. A barrister could be on a planning inquiry for 3 years, engaged by one engager, but that doesn't take the barrister into the realm of employment for the duration of that inquiry. One has to look at the wider picture. And indeed, the Master of the Rolls, Sir John Donaldson, as he then was, made clear in O'Kelly that even working for a single client will not of itself make an individual an employee of that client. The reference, if the court should need it, is page 191 of the authorities bundle, page 126H of the report. We say that both tribunals below correctly evaluated Ms. Adams' hypothetical employment status by reference to the hypothetical contracts that they had before them. In other words, if the Upper Tribunal was right on the autoclaims point, and it then formed the hypothetical, it then discerned what the hypothetical contracts were, we do not challenge its categorization of those hypothetical contracts. But equally, we say that the Upper Tribunal was wrong on the autoclaims point, and therefore the first tier, on its determination of what the hypothetical contracts were, was also correct in its analysis. My final overarching comment is by referring to a submission made by HMRC in last week's appeal, a click about it. Paragraph 12 of their skeleton argument, which I'll just read out just in case the Lordships don't have it to hand. The Upper Tribunal reached a number of evaluative conclusions, both in finding the terms of the actual contracts between then KPL and TalkSport, and in its application of the second and third stages of the RMC test when remaking the decision. This court should approach an appeal on such a matter from a specialist tribunal with an appropriate degree of caution and not be too ready to find a misdirection of law. This warning reflects what was laid down by the then president of the EAT, Mr. Justice Elias, as it then was, in Asliff and Brady. If I could ask your Lordship to turn very quickly to page 374 of the authorities bundle, we can see what His Lordship said. Paragraph 55.
Yes, hold on.
And I'll particularly highlight, halfway through the paragraph, that an appellate court should not use a fine-tooth comb to subject the reasons of the fact-finding tribunal to unrealistically detailed scrutiny, so as to find artificial defects, and then later on, infelicities or even legal inaccuracies in particular sentences in the decision will not render it itself defective if the tribunal has essentially properly directed itself on the relevant law. And if I could, on the same point, direct the court to page 457 of the authorities bundle, where we see what Lord Justice Mummery said, or was cited to have said, in another case on the same point.
Could you give me the page reference again, please?
457, my lord.
I see. This is part of Weight Watchers.
Is it part of Weight Watchers? But the important bit is the Court of Appeals reasoning. The reading of a decision halfway through must not be so fussy that it produces pernickety critiques. Over-analysis of the reasoning process being hypercritical of the way in which the decision is written, focusing too much on particular passages or turns of phrase, to the neglect of the decision read in around, those are all appellate weaknesses to avoid. That is my initial 10-minute overview, which probably has lasted more than 10 minutes. That's the way that these things. But what I now propose to do is to start my detailed submissions, particularly on the Hall and Lauren point. And what we say is that there is no inconsistency between Hall and Lauren and ready-mix concrete. We say that Hall and Lauren is a direct application of the third stage of ready-mix concrete. and that the only way a decision can be made in a case such as this is by looking at the wider picture, not just the terms of the contract under consideration.
When you say the terms of the contract under consideration, do you mean the actual and the hypothetical?
Well,
Or the hypothetical?
it would be hypothetical because the employment status question is applied to the hypothetical.
Once you've got to the hypothetical, then you do the question. Then you do the employment status question.
Indeed.
Right, so when you're talking about not just the terms of the hypothetical contract.
My lord, sorry, maybe I misheard you.
Sorry, must look at the wider picture and not just the terms of the hypothetical contract.
Indeed, yes, that's correct. You look at the context in which that hypothetical contract is hypothetically situated. So with the canter through the case law, which I intend to embark on in a few moments, I will show that Hall norma is and remains good law, applicable in cases such as the present. And then, in due course, I will address each of HMRC's 3 sub-grounds on ground number 1, in paragraph 17.1 to 17.3. But the authorities I'll be relying upon all are subject to a considerable amount of overlap. Without going to avoid unnecessary repetition, I will be going through all the authorities more or less in one go, and only going back to the authorities when looking at the alternate points. In short, the 3 headline points that I will derive from these authorities: number 1, Hall norma is an application of, rather than a deviation from, RMC 3, like the 3rd stage of ready-mix concrete. It requires a tribunal to consider the whole picture.
Right, this point 2.
This is, yeah, indeed, my lord. The whole picture, i.e., all the circumstances, and not simply the terms of the particular contract in isolation. As a parenthetical note, I would add, there will be plenty of cases, Weight Watchers is a good example, where the only relevant facts are the terms of the contract. But where the facts merit it, one should look beyond that, because the whole picture is in fact what one's meant to be looking at. And the 3rd headline point, which to some extent there is now common ground. The term business on one's own account is not a separate test, but is generally used as a label for providing services otherwise than as an employee. The whole picture approach, and this is effectively my summary of all my 3 points, is consistent with the realism that my learned friend appealed to at the beginning of this morning's proceedings. And if I can pick up a point that Lord Justice Arnold raised earlier, where does the frame go around the picture? We say whole means whole.
No frame.
No frame other than relevance.
How do you decide what's relevant?
That is for the fact-finding tribunal to decide, in the same way it decides which way. So, for example, if a fact-finding tribunal said, we decide this because reason A, he was born on a Wednesday, that's clearly irrelevant. But otherwise, it is for the fact-finding tribunal to decide what is relevant and whether how far to cast the ring.
Subsequent conduct? Subjective intentions?
Subsequent conduct and intentions will often be relevant when going from the actual contracts to the hypothetical contracts, because it's common ground that there is not a complete matching process. But what I would suggest to the court is that one is not at this stage focusing solely on interpretation of a contract. What does a contract mean? One is actually going beyond that and categorising the contract. And to categorise a contract, I would submit that the picture, the frame, is quite widely drawn. The problem, if one limits oneself, as my learned friend is urging this court to do, to the terms, the contractual terms itself, is one will find that the frame will be so narrow that one will never be able to get outside an employment context once one's in.
What about facts that are known to one party only and not to the other contracting party?
Again, I might say that those facts are part of the wider picture. If Cameron McIntosh were to engage Dame Judy in her personal capacity, so that she doesn't assume she doesn't use a service company, it is for Cameron McIntosh to decide whether or not she is employed or self-employed. But they have to decide under current law, and it's been like this for since 1944, whether or not to operate PAYE. Nothing to do with R35. The Cameron McIntosh will not know the terms of Dame Judy's other contracts. They will know of her reputation, undoubtedly, but they won't know the precise terms on which she was paid for every other engagement she's had over the course of an illustrious career. But, nevertheless, when there is a dispute, whether it's between Dame Judy and Cameron McIntosh, or whether it's the revenue coming in, then all the relevant facts, or all facts, are potentially relevant.
So all the terms, all her other contracts, even though not known to Cameron McIntosh. How is that a possible conclusion?
It's, if Dame Judy is building up a picture that she is a self-employed individual, then arguably she would have to make good that contention by saying, I was engaged on this film for 6 weeks, I was on tour with this company for 6 months. Ultimately, it's for individual parties to decide what evidence to put forward. And one of the authorities, I can't remember which one it is offhand, talks about the problem there's always going to be some incompleteness of evidence. But to say that the categorisation of Dame Judy's contract with Cameron McIntosh is determined solely by looking at what is contractually agreed between those two parties must be wrong when looking at employment status.
What you say, it's unreal.
I'd say that's unreal.
Yes, you say it would be unreal to do that.
Of course, because it will give you the wrong result in most cases, if not all cases. Because I'm I'm starting from the presumption that there is no dispute that Dame Judy is a self-employed actress, or actor, I think we would have. And different roles she takes, in the same way as with the Davis and Braithwaite case, different roles are just incidents of that wider self-employment. Taking that as a starting point, because we know what the end result is going to be, the only way we can get there is by looking at the wider picture.
Then you're assuming what you're trying to prove.
Well,
You're saying we assume she's self-employed, therefore all the evidence that proves that she's self-employed comes in.
My lord, I'm certainly not saying that you're starting from that position, and therefore that will prove the point. But it is a factor that has to take into account. There's no disagreement between my learned friend and me that one can have in parallel self-employment and employment. I don't want this court thinking that there is any argument that one can only fill in one set of pages on a tax return. That's always been common ground. But we say highly relevant is your wider self-employment carrying on. this point, would it be helpful if I now take the court through the canter through the authorities?
Just before you do, can I just pursue this question? Because you've made an important point at the outset of your submissions, which is that it's the standard common law test of employment.
Indeed.
So how does the approach you're advocating here work in the health and safety context? Are you seriously suggesting that if it's a health and safety issue, and you need to know whether the person is employed for the purposes of assessing the relevant legal liabilities, that you therefore got to take into account terms of contracts with third parties which are not known to one of the relevant contracting parties? How is that going to work in the health and safety context?
My Lord, what I'm saying is if the health and safety legislation ultimately focuses on the common law test of employment, I'm saying that the wider picture has to be used, has to be followed as appropriate in all cases. So I'm not saying that if Dame Judy were to assert her self-employment on a particular role in the West End, she will not need to show every contract with every client over a number of years. All she will need to do is to show she's got this self-employment going on, undoubted, undisputed self-employment, of which this is one engagement within it. You don't need every term. It's up to the individual witness or the parties to decide what evidence to put forward and how much detail to put forward. But I'm certainly not suggesting that every single fact of every single contract is going to be necessary to produce. What one is trying to do is to form a picture with the details before the court. And if the picture is of self-employment, that is that's the answer.
Now, Mr. Gordon, were you about to start on cases?
I was about to start on ready-mix concrete. I was going to give a couple of second overview before we even need to look at ready-mix concrete. Maybe that's helpful if I go to that before.
Well, I'm just leaving it open to you to say whether you'd rather start on a run of cases in the morning. We seem to be.
If I may just start a bit, and then we'll just see where we go. What I wanted before we even need to open the open bundle of authorities. What I wanted to say is just take a step back. What was ready-mix concrete doing? What's the importance historically?
All right. Well, let's deal with that point, and let's not go to any authorities.
That's
on paper this evening. Right. So, what was ready-mix concrete doing?
Before the 1960s, there had been the long-established Victorian test of master and servant, the control test. By the middle of the last century, it was realised that that was no longer appropriate in many cases. And what the courts were doing, both within this jurisdiction and elsewhere, were trying to devise alternative strategies. And the most famous example would probably be Lord Justice Denning's approach in some of the cases literally in the middle of the century. But none of those alternative strategies proved themselves entirely satisfactory.
Was that part and parcel?
That's part and parcel in particular. Well, what we have from Mr. Justice McKenna is to distill the early authorities, looking across various seas to come up with a working test. But what I will be making good tomorrow is that working test incorporates what we now see as the Hall and Lorimer approach. As I say, there is no inconsistency between them.
Sorry, just so RMC, you said, distills the earlier authorities.
Yes.
And then what did you say? To come up with
a working test.
Working test. Yes.
That has indeed, now adding words to what I said before,
Yeah, yeah.
has stood the test of time. And I will show tomorrow that Hall and Lorimer is consistent with ready-mix concrete itself and the subsequent applications of ready-mix concrete.
Right.
Given, my Lord, Lord Justice Peter Jackson's comments, I don't propose saying anything more at this stage unless your Lordships have any questions.
Thank you very much indeed, Mr. Gordon. We'll resume at 10:30 tomorrow morning.
Cool.